Assalamualaikum and good evening to Dr. Zokri. Today we are going to present about our assignment 2, which is the cases between PST Energy 7 Shipping versus OW Bunker Malta Limited. For this assignment, we are going to explain about the cases that happen between two companies. This cases is about an issue of sales contract that conflicting between two companies that dealing with business, which is PST Energy Ltd, as I said, and OW Bunker Malta Ltd. It was UK Supreme Court who took in charge of this case to solve it in the right way of an international business. It was stated that Section 2(1) of the Sale of Goods Act 1979 characterized the sale of products as a contract by which the dealer transfers or agree to transfer the property in products to the buyer for a money considerations, which called the price. There are accordingly three reasons why a contract may fall outside that definitions and hence the Act jurisdiction. First, there may be no transfer of property within the product as in development where there is transfer of ownership but not possessions. Second, the transfer may relate to subject matter other than merchandise. Third, there may be an absence of money considerations. I'll proceed with the background of PST Energy Limited, which is the active company incorporated on 6 September 2018 with the registered office located in Aberdeen, City of Aberdeen, Scotland. PST Energy Limited has been running for 2 years. There's currently one active director and one active secretary, followed by one operations supervisor and one rentals administrator. According to the most recent confirmation statement submitted on 20 June 2020, basically, PST Energy Ltd provide rentals, sales, and services of surface and downhole drilling tools, equipment, and ancillary equipment as required in support of the international energy industry. With a solid improvement of the management and therefore the flexibility afforded to an independent limited company, PST Vitality Ltd are able to support bespoke and supply rental package, particularly to the oil field and energy extraction requirements. They are also able to offer the sales of new premium use and manufactured equipment, whether standalone sale or in conjunction with rental to package. Moreover, through the knowledge, experience, and mastery of its workforce, PST Energy Ltd are able to offer the extra services such as full drill stem management and multi-process coordinations. PSC Energy Ltd was handled by four main men or an important person of the organization, which is the managing director, Mr. Greg Mitchell, an experienced director with a demonstrated history of working in the oil and energy industry. The next is the operations supervisor, Mr. Brian Peters, an experienced operations supervisor with a demonstrated history of working in the oil and energy industry. Moving on to the next person who hold the secretary position, which is Mrs. Alison Mitchell, an experienced administration professional with a demonstrated history of working in the oil and energy industry. And for the last person that included was the rental administrator known as Mrs. Alison Elliott. She's an experienced administration professional with a demonstrated history of working in the oil and energy rental equipment industry. So I'll be moving on to the PST Energy Ltd duties and obligations. According to the law of international business, this company activities and type of services are fall under three major law, which is rental equipment agreement, law of sales of goods and services law. For the rental equipment agreement that used by this company when dealing with the tenants, the company duty is to make sure all the rental equipment in a good condition and well maintained to be used by the tenants. It is to confirm that the rental services are trusted and will not creating such an issues or problems on the equipment and the tenant will be at fault for that. The next law is sales of goods as this company will also selling the equipment which is new, premium use and manufactured equipment. One of the most important sections on this law, which will be duties for a company to bear with, is the equivalent quality of the product to be confirmed as the description before selling. With this law, the buyer will be safe to buy any product from this company as it will cover any defect which is not mentioned in the description of the product. For the last involved law in with this company is the services law. Considering this company also provide services such as full drill stem management and multi-process coordinations. For these sections, the company duties is to be in full responsibilities on the services provided to the customer, which means from the beginning until the very end of the services durations, the company must make sure the services provided are safe and complete. Just like in the details of the services and the written agreement, which is the contract between the company and the customers. So that's all for my part. I will pass to the next presenter, which is Muhammad Said Wakilid. Thank you.
Okay, thank you, Arif. My name is Muhammad Sewakudin and I will present about the OW Bunker Malta. The background of this company is OW Bunker was a Danish marine fuel bunker company that had operation in 29 countries when it was founded in 1980. It operated a fleet of around 30 bunkers vessels and served as a physical distributor and reseller of marine fuel. It also offered risk management solution to help control costs, reduce risk, and protect against market fluctuation. By revenue of 70 billion, OW Bunker was the second largest listed company in Denmark after Maersk at the end of 2013. OW Bunker was listed in Denmark's second largest initial public offering IPO since 2010. Alter Fund II, which had controlled the entity since 2007, remained the largest shareholder. It was the world's largest bunker supply until it went bankrupt on November 7, 2014. In less than a year, it went from IPO to bankruptcy. The company dramatic demise propped a rush of litigation in English courts. Okay, the OW Bunker Malta duties and obligation. According to the law of international business, this company activities and type of service that have been provided by the company is mi- microeconomic law, intellectual properties law, and the LGRC. For the microeconomic law, it is a supply law that states all else being equal, as the price of a goods and or service rise, so will the quantity of goods or service offered by suppliers, and vice versa. The OW Bunker is well-known Danish company and one of the largest in the bunker supply business. Bunkering is the process of supplying fuel to the ship, which include the shipboard logistic of loading fuel and distributing it among available bunker tanks. The next is the intellectual property law. The law is concerned with law that protect and enforce the right of creators owner of invention, writing, music, design, and other works known as intellectual property. Intellectual property license is extremely important in business, academic, and broadcasting. Business practice such as franchising, technology transfer, publishing, and character merchandising are entirely dependent on intellectual property licensing. Land licensing, proprietary licensing, and intellectual property licensing. It also includes the licensing law that are used by the OW Bunker to operate in 29 countries. For the third and the last that involved in the legal governance, risk management, and compliance, or they call LGRC. The complex set of processes, rules, tools, and systems used by the corporate legal department to adopt, implement, and monitor an integrated approach to business problem is referred at, is referred to as LGRC. OW Bunker employ this method as well as risk management solution to manage business problem and OW Bunker was the second listed company in Denmark at the end of 2013. For the conclusion, the conclusion in this case study of ownership retention terms in sale contract gone astray, PST Energy Shipping versus OW Bunker Malta Limited. As you can see, we have discussed the two companies' duties and obligation. The distinction between duty and obligation when it's used as nouns, duty refer to what one is morally or legally obligated to do, whereas obligation refer to the act of binding oneself to someone through a social, legal, or moral tie. The directors are the company heart and soul. and they are the key to success. The company management should be in the hands of responsible people who can use their power wisely. As greater power comes with greater responsibility. The company is run by a board of directors who make all decisions collectively through organization meeting. Despite the fact that there have been numerous instead of company mismanagement, the directors are the first to be held as accountable in this regard. In the event of mismanagement, directors are primarily obligated to indemnify the company. However, there are times when the general public suffer as the result of the company mismanagement. As a result, there should be provision and measurement in place to prevent this from happening. Okay, that is all from my part. Thank you.
Okay, for the next part is my name is Zahid Zahid Kifli. The summary of the article journal. PST Energy 7 Shipping LLC are known as the ship recogitants on November 4, 2014. The ship was supplied at 110 metric tons of gas oil and 1,000 metric tons of fuel oil at the Russian port by a company OW Bunker Malta Ltd. The court noted that the substance of the contract, the critical terms in my view, are to be found in the agreement for 60 days credit and in clauses which provide the property in the bunkers is not to pass until they have paid for in full, but that the owners have the right to use them for the propulsion of the vessel from the moment delivery. It is a contract under which goods are to be delivered to the owners as bailies with a license to consume them for the propulsion of the vessel. Coupled with an agreement to sell any quantity remaining at the date of payment in return for a money consideration, which in commercial term can properly be described as the price. The court extended the law of sale of goods to the contract, the commercial background, and the terms of the contract make it clear what the owners contracted for was not the transfer of property in the whole of the bunker, but the delivery of a quantity of bunkers which they had an immediate right to use, but for which they would not have to pay until the credit expired. Section 2(3) clause 6 can readily be applied whether there is a condition regarding passing of property to which all of the goods covered by an agreement are subject, but that is not the case here. Number 2, it ignores the fact that there is no condition governing the transfer of property in the bunker used before the payment. The property in the bunker consumed never passes and is never agreed to be passed. And number 3, it focuses on the agreement to pass property in the bunkers surviving at the time of payment, when the agreement was a single contract to pay a single price for all of the bunkers sold later not than 60 days after delivery. Whatever had happened to such bunkers in the meantime, the agreement is a single agreement which cannot sensibly to be treated as divisible. The following was the term on the title in the OWBM and the ship owner's contract H1 title in the to the bunkers delivered and all property rights and to such bunkers shall remain vested in the vessel seller until the full payment has been received by the seller of all amounts due in connection with respective delivery. That is all for the summary. Next is the type of dispute for arbitration. This case type of dispute is the arbitration. Arbitration means that when the disputing employer and union cannot find a solution made by themselves with the help of DG, arbitration may be the only way to settle the dispute. In arbitration, an impartial third party, which is commercial court and court of appeal, is given the authority to settle the dispute by examining the information given by both sides and then make the judgment. arbitration explanation. The Court of Appeal, agreeing with the commercial judge, concluded that the contract was not sale of goods, as the ship owners had consumed all the bunkers in 60-day credit. There was no breach by the OWM in transferring the ownership to them. Thus, the ship owners must pay OWBM. The court noted that for this reason, I agree with the judges that the transfer of property in the bunkers from OWBM to owners was not the essential subject matter of the contract, that failure to transfer property in the bunkers, all of which had been consumed when the period of credit expired, did not reveal the owners of the obligation to pay for them. That's all for me. Next is Muhammad Muflis.
Okay, Assalamualaikum and good evening. Okay, so my name is Mukhriz Zaki and I will be presenting about the procedures for the dispute settlement. There are 7 procedures for the dispute settlement, and the first one is the filing and initiation, which means the procedure begins when one party files a demand for arbitration. As for the arbitrators, the second procedure is known as arbitrator selection, where all parties seek to find an arbitrator with whom they can reach an agreement and who can satisfy their needs given the nature of their disagreement. The procedure is named as preliminary hearing, where both parties will meet to discuss the key case issues, their knowledge sharing and witness list, among all other things. The fourth procedure involved the information exchange and also preparations. This procedure involved the parties to exchange the details and information, and arbitrators will deal with any issues that may arise. The fifth procedure is the hearings, which means to the arbitrator, the parties will submit the proof and testimonies. Not only that, the parties will exchange the details and arbitrators will deal with any issues that may arise. For the sixth procedure is known as the post-hearing submissions. Post-hearing submissions involve the parties. During this procedure, the parties can provide additional details to the arbitrator if it is deemed appropriate. The last procedure is named as the award, where this means the arbitrator will decide. Uh, by decides it means is the award, and then after that, after the arbitrator decides, the case is closed. The next slide, right? For the last part, my last part will be our own opinion about the issue regarding the issue that we have chosen. In my own opinion regarding the issue, the owners could not use the Section 49 of Sales of Goods Act as a defense to a lawsuit for the price, because the deal was not really for sale. It was not known as a deal for sale, actually. Furthermore, the Supreme Court determined that the OWBs only stated that obligation in relation to the bunkers was that it was entitled to grant the owner's permission to consume bunkers prior to the payment made. OWB did not need to buy the title to the bunkers. What it required was the right to approve their use under the contractual supply chain, which it did according to the Supreme Court. In addition, the decision may have consequences, implications for a variety of other Sales of Goods Acts arguments. In order to reduce and minimize the risk in commodity transactions, and also at the same time protect the the buyer's positions, standard business terms and conditions, not just those relating to the bunker supply contracts, will need to be reconsidered again. Okay. For last but not least will be the conclusion, the overall conclusion. Conclusion in this case, study of ownership retention terms in sale contracts gone astray. BST Energy 7 Shipping versus the OW Bunker Malta Limited. As you can see, we have discussed the two companies' duties and responsibilities. Distinction between duty and obligation when used as nouns. Duty refers to what one is morally or legally binded, legally obligated to do, whereas obligation refers to the act of binding oneself to someone through a social, legal, or moral tie. Directors are the company's heart and soul, and they are the key to its success. The company management should be in the hands of responsible people who can use their power to good use wisely. As greater power comes with a great responsibility. The company is run by a board of directors who make all of the decisions collectively through organizing meetings, despite the fact that does it apa screen ni?
Okay.
Okay. Despite the fact that there have been numerous instances of company mismanagement, the directors are the first to be held accountable for any issues arise. In the event of mismanagement, directors are primarily obligated to indemnify the company. However, there are times when the general public suffers as a result of the company's mismanagement. As a result, there should be provisions and measurements in place to prevent this situation from happening. Okay, that is all from us. Thank you.
So from us, thank you.
Thank you, sir.